Sit down. Sit down. Sit down. It's okay.
Okay. Looks like we are recording. Okay, welcome to Contracts for your MLS program. I am your professor, Venus Trunnel, and hopefully we can get to know each other this session and also learn something about contracts in the process. So is this your first class with Trinity, or have you guys taken other classes through Trinity?
Second.
Second class?
Mm-hmm.
Second class.
And that was with Professor Friedman?
Mm-hmm.
Okay. And you are Robin?
Yes.
Okay. And I saw Pandora.
Go. And Army.
And Jennifer. I see you're on mute, Latina. Okay.
Yeah.
And let's see. Okay, so
Me.
yeah. So do you guys have any just general questions for me before we get started with our official PowerPoint and contracts lesson?
I have one. I'm Jacqueline Cook. Did you get me?
Okay. Yes, I did.
Okay, thank you.
Go ahead, Jacqueline. That's what you wanted to know, if I got you?
Yeah.
Oh. Now, is Johnny online? Johnny or Yvonne?
I'm here.
Yvonne?
Yes, ma'am.
And, okay. And then the other one is Veronica? Margarita? Or LaDarla Richardson? Okay. All right.
I
So
want to
basically,
apologize that I don't have video. I'm actually changed shifts, so I'm at work now. So,
is that you, Yvonne?
yes, ma'am.
No problem. No problem at all. We don't have to see one another. Just so long as you can hear. So I've been teaching at Trinity for about 3 years. I teach intellectual property, and I teach legal research and writing and contracts. And so the online class, this is my second online class, even though I've been teaching at Trinity for 3 years. And in my private practice, I do mostly intellectual property, and I do code enforcement for County of San Bernardino, and for property code violations. So that's kind of my background. And I enjoy teaching, and I'm looking forward to, doing more of the online platform. So what I'm going to try to do now, if no one else has questions, I will try to share my screen, and we can go through the PowerPoints. And then you can ask questions throughout. Email me if you have questions. I know Ryan, do you guys have Ryan's email address?
Yes.
Okay, if you have problems or questions with access, I think you need to discuss it with Ryan first.
Yeah.
And then, if you need to get in contact with me. But if you can't make a live session, we have 2 live sessions tonight and then one in the 5th week. At any rate, let me know ahead of time so that I know you won't be attending, and then you can review the PowerPoint and review the live session, and then submit those questions to me in writing, and you will get credit for the live session. So you have this one and then one more, and then your final. And so just be in contact with me. So Margarita is Marga. I saw you.
Yeah, Margarita Perez. Hi. Good evening, everyone.
All righty. And John Slim?
Yes, that's me. I'm Johnny Johnson.
Oh.
Can you hear me?
Is Veronica online? Okay, so let's do this. I'm going to share my screen, and we'll go through the PowerPoints. Okay, can you guys see my PowerPoints okay?
Yes.
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 Okay. Okay, so let's do this. Okay, contracts law, Trinity Law School. Okay, so this course will cover
Lighting on here.
basic contract law principles. By the end of the course, you should be able to answer the following questions, and these are from your textbook, the headings from your textbook. Has a deal been made? That's what we will go over tonight. Is there an actual contract? And then, is that deal enforceable that you made? Are there defenses to enforcement of the deal? And then, when will your performance of the deal be excused and not a breach of contract? And then, how does the law enforce the deal? And finally, who else is affected by the deal? Sometimes we make contracts and other parties are affected by the contracts that we make. And they may or may not have a claim or be able to bring a claim, even though they are not parties to the deal. And so that's what that final chapter will deal with, third parties who may be affected by the deal and if they have any type of standing to bring an action. Okay, so what is a contract? Did you guys review the video? I think Laura Friedman had that same video for what a contract is. Were you guys able to review the first, I think it was like 3 or 4 minutes, the video?
Yeah.
Okay, so a contract, what is it? Is basically an agreement between two parties that creates an obligation to perform or not to perform a particular duty. A contract must include an offer, an acceptance of that offer, and then it must be supported by some type of consideration, meaning that you're giving up something or you're doing something in exchange for that offer and acceptance. And so we'll go over that more in detail on what consideration is for the next chapter. And you can email me questions or just post them on the media or the discussion board, answer those questions. And then this unit will focus on the first 2 requirements of a valid contract. So what I do want to say is, just in general, when you are responding on the media posting or the discussion board, make sure that your answer includes the contract language or terms you are finding in the book. You need to be able to apply those terms. So your answers should include those terms, not just in general. It should include whatever the contract is talking about. So, for example, a contract you may have made, I think is the discussion post for this week. Use offer. Who made the offer? Who accepted the offer? Who were the parties? So use those terms when you are responding on the board or on your media post. Okay, so let's move on.
That's interesting, yeah.
This unit focuses on the first 2 requirements of a valid contract. On has a deal been made? Is there an offer and did someone accept it? And we also call that mutual assent. That is an agreement. You have to agree to something. So what are the components of mutual assent? I just passed that one. Okay, so mutual assent means an offer and acceptance, and it's looked at objectively. Will someone looking on the outside see that someone made an offer, and was that offer accepted? And did they have an intent to agree? So a reasonable person in the position of the promisee must believe the other party intended to be bound and the promisee must have actually so believed. So you believe that that person is intending to make a contract with you, you know. And so why is that important?
Well, I guess that would be sort of like a precept until it's an actual contract is made. That's sort of like something prior, a prior statement, I guess.
Right. It may not actually be a contract yet.
Yeah, we're talking about it. We're talking about it.
So that would be pre-contract negotiations is what you're talking about, right?
Okay, pre-contract negotiation.
Okay. So offer defined. An offer is a promise by one party made to another party to do or not to do something in the future. And it's contingent upon the other party's acceptance, okay? It must be communicated by words, conduct, or a combination of both. For example, if I say, will you wash my car for $10? Okay, I am offering you something, I'm communicating something that I would like you to do in the future. And so that would be an offer. Okay, you're offering that party to do something for you in the future. Okay, and then once an offer is made, the offeree has the power of acceptance. We call it power because if they accept, if I say, will you wash my car for $10? And you say yes, then a contract has been made. They have that power to bind you so that if that other party washes my car, then I have to pay them $10. And if I don't, then I basically breached that contract. And so if the offeree, or the offeror, I should say, really intends that a contract should be made when they are communicating that offer, you know, they are intending that a contract will form once that person does accept. They have to have that intent. And so the power of acceptance gives the offeree the ability to create a binding agreement. So remember, an offer must directly or indirectly be communicated, indicate a desire to enter into a contract, be directed at some person or persons, invite acceptance, and it must create a reasonable understanding that upon acceptance, a contract will arise. Just think about it. If I say, I'm going to ask my son to wash my car later, but I never say anything, okay? And if he doesn't, and I can't get mad at him or sue him because he didn't, right? Because I never communicated anything to him. He had no idea I thought about it, right? So you have to communicate. Just think of it logically that your person has to know you're making an offer to them to, you know, to invite that acceptance. So what effect does the intention of the contracting parties have on whether a contract has been made? Anybody want to take a stab at that?
Yeah. Apparently, if the party is not sincere in what they're contracting for, and you are aware of it, and that it is not a real contract, not enforceable.
Right, exactly. My example of the red Ferrari is I'm stuck on the road in my red Ferrari, which I don't have, by the way. But hypothetically speaking, I'm stuck on the road in my red Ferrari. I don't know, you know, I don't know what's wrong with it. You come along and you're able to fix it. And you know more about cars than I know. I can afford to drive one, but you know more about cars than I might know about the car. And I say, I should give this car to you for helping me. Am I really intending the contract or to offer you my car? Or am I just happy that you were able to help me? Would you take me to court and say, he said he would give me, or she would give me her red Ferrari because I helped her?
No.
Right. So you
They
have to
actually
think about
believed it.
are they really intending? So that's why the intention of the parties is very important, because they have to have that intention to be bound to enter into some type of arrangement or an agreement with you. Any questions about that, the intent?
Mhm.
Okay.
Yeah, I guess that's why they always say put it in writing, huh?
Well, yeah, it's always good to have a writing evidencing a contract, but a contract is not required to be in writing. Most contracts, there are some that are required to be in writing. For example, if you're selling a home, you have to have that contract in writing.
Yes.
But most contracts are oral. You know, they're not written down. Okay, so mutual misunderstanding of contract terms. So the doctrine of mutual misunderstanding, if the parties agree to use the same term but attaches a different meaning to the term. Okay, back to the red Ferrari. So A offers to sell B his red car for $1,000. B is excited because he has only seen A in a red Ferrari. A means his old red 2007 Honda Civic. Is there a contract? Anybody?
Not really. No.
Right. Because they attach different meanings to red car, right?
Yes.
Right.
A meant his old red 2007. B thought it was the red Ferrari, you know, which is a whole nother question, because is someone really going to sell their Ferrari for $1,000, even if it doesn't drive? You could probably get $100 more for just the parts. So that would just not, you know, that wouldn't fly. But they
Well,
have a mutual, the
you
point is
do
they
have
have
a
a
car for
mutual misunderstanding of
$1,000.
the terms. I didn't hear what you said. Is that John?
No, I was actually had to reread this and break it down and stuff. So he do have a red car for sale for $1,000,
Right.
but not a Ferrari.
Not the Ferrari, because they attached different meanings to red car.
They put
Okay.
it.
A meant his red Honda Civic, and B meant the red Ferrari. So, but it's a mutual misunderstanding. They attach different meanings to the term. So in that case, there is no contract, basically. That is the result of that. If you're attaching two different meanings to terms, then there's no contract as it relates to those terms. Okay, so what is the result? No contract. The contracts require mutual assent. You have to have an understanding of what those terms is when you negotiate. So let's compare uncertain offers. What is that? Uncertain offer. So basically there's two types. There's price quotes and then general public advertisements. The general rule is that those price quotes, if they're uncertain and they're general public advertisements, they are not offers. There's no offer. Basically, they're viewed as invitations to offer. Like when you see an advertisement on TV, that is an invitation to offer. They're not offering you, no contract is made until you go there and say, I want to buy this.
Mm-hmm.
Then there's a contract. But typically, just a public advertisement is not an offer. It has to be more. But there can be an offer if, an option contract, if it remains open for a specified period of time or on specified conditions, that is supported by some type of consideration, a statute, or reliance. And so to give you an idea of that. Okay, so the example, you go to your local your local electronics store advertises a Black Friday deal that they will give the first 100 people in line a 60-inch smart TV. You want that TV, so you skip your Thanksgiving with the family and camp out in line for 3 days. Is this an irrevocable offer? And how is it different from a general advertisement? Probably an option contract, right? Let me go back and explain that. So basically, there is some type of reliance on you. If you skip dinner and you go camp out and you're one of the first 100 people, they have the terms are a little more specific, right? You have 100 people, you're in line, and you get this TV. So if you're one of those 100 and you have that reliance, you go, you skip your Thanksgiving dinner, they can't revoke that offer. That's an irrevocable offer. You did what you needed to do to get that TV.
100.
And so you can't revoke it. The electronic store can't say, oh no, we're not giving away those TVs today. Come back next week. You can't do that.
Professor, would another example be that a store advertises something on sale X number of days, so it has a specific end date, and then you come to the store to purchase it prior to that specified date, but they don't have it in stock? Would that be an irrevocable offer, and is that why they would then give you a rain check?
Possibly, unless they say until supplies last.
Right. No. They say
a week, but if they run out, they covered themselves, right?
No, but they are not saying until supplies last. What they're saying is this item will be on sale from X date to X date.
Right. Yeah.
I guess I kind of think about how sometimes you go into a store and something may be mismarked, or they may have a sign that's saying this is 50% off, but this set of items aren't really 50% off. They're regular price. Because that sign is posted there, they give you the 50% off.
Right. Yeah, I mean, some stores will do that, especially if it's not clear. A lot of times it will be specific, and they might say the front rack, or they might put the brand. Or you might put, like, I know Nike does this all the time, their factory store. They'll say 40% off, tops only, but then you see bottoms on the rack too.
Right.
They were specific in what was 40% off, right?
But that was
they would honor that 50% off.
Okay.
Yeah, and sometimes it just depends on the store and good customer service. Depends on what store you're dealing with.
Management.
Yeah, and that too. And then we have the UCC. When you're talking about the Uniform Commercial Code, you are always talking about the sale of goods. It provides that a contract between merchants, business to business, that is in writing, and it states that it will remain open and may not be revoked for a period of time stated, or for a reasonable period of time if no time is specified. This is called as a firm offer. I can't take that offer back if I'm a merchant and I say that it's going to be open until this time, or you give it a reasonable time if there is no time period stated. And how you determine reasonable is looking at how they might have dealt with each other in the past, or how other companies might deal with what they offer. You may not be able to come back a year later and say, hey, you made this offer. I want, you can't go back on it. You can't revoke it. But if it's a week, that might be reasonable. But a year, probably not. It's probably unreasonable amount of time. But it's a firm offer because it's dealing with the sale of goods, and it's between merchants, business to business. Okay, and so basically option contracts are irrevocable. And so an offer that foreseeably induces some type of detrimental reliance of a substantial character by the offeree may be enforced as a binding contract to prevent injustice. Okay, we're dealing with offers now. Offers that remain open or that have more. Remember, an option contract or a firm offer has to have more than just a regular offer. It has to have something else behind it, like the TV, the first 100 people. There's a little bit more than that. Okay, and so you can also enforce an option contract if someone relies on it to their detriment. And for example, if A offers to sell B his laptop for $300 if he goes to school. So if B doesn't have a car and he says, okay, well, I'm gonna get a car so I can go to school, and then he pays the $150 enrollment fee in his technology course at a local college in reliance on A's offer, okay? Then there's an option contract because B took some steps, he bought a car and paid a $150 enrollment fee so that he can purchase your laptop for $300. So B can't say, oh no, I'm not gonna sell it to you now. The law would probably allow A to get that laptop for that price because of the detrimental reliance of B on A's offer.
Interesting.
So did you have any questions about the discussion board? I think that's your different contracts that you've entered into. Have you guys made any postings yet?
Yes.
Yeah, I did mine this morning. I'm not quite sure if I did it right, but I made a good attempt at it, I believe.
Well, I will definitely look at it. I try to, at least the first discussion board, I try to respond to all of you. Usually in the, unless you're kind of off track, I probably may not respond to everything. But for the most part, if you have the understanding, and you're not off track, I may not respond to you specifically. And then if I see that there are a lot of people with the same issue, I will make a general response, or I'll send an email or a message to everyone saying, look, you got to look at it this way. So I take a pulse of the class that way to see if you have the understanding. But yeah, I will try to respond to most of you because we make contracts every day, right? How many of you knew how many contracts you were entering in pretty much weekly before you took the class or read the first chapter?
I did.
Yes.
Heather,
Yes.
I just want to verify that we're going by the due dates in the syllabus.
Yes.
Okay.
Yes. So Thursday, I believe Thursday at midnight is the discussion board.
Friday.
Friday. Yeah. And then the media posting, and then you have to respond by Sunday. So whatever the syllabus says is what you should stick to.
Yeah, I have a question.
Yes.
We'll be meeting here.
Okay, so what kind of contract would it be if you take your animal to see a veterinarian and you pay cash for x-rays or whatever needs to be done? And how, I know it's kind of a contract, but in what, are you the offerer, or how does that work? Or is it one of these other option contracts, or how is that work?
Right, you offer to pay them money to look at your dog and make, and they will look at your dog and then you make that payment, right?
Right.
So, or they provide the service.
Okay.
So wouldn't it be that since the veterinarian is actually providing the service and sets the price fees, would they be the offerer?
Right. Typically, the business is the offerer, and you're accepting it by when you pay, or you make that, or you give the veterinarian your dog. You're accepting the terms that the veterinarian is saying to you. Okay, I will look at your dog and I'll do X-rays at this price or whatever. So typically, they are the offerer, and you are the offeree. You're accepting their terms. Jennifer had a question.
I did. I missed the whole first part because I had no sound.
Oh.
I don't know if you did introductions or anything like that because I got on right as you were said in the PowerPoint.
Oh, yeah. You know what? Just review. You didn't miss anything. I just went through the PowerPoints. Did you just get on now?
No, I started when you started the PowerPoint, so I only missed
You didn't miss
like.
anything. You didn't miss too much.
Okay.
I just said what I do. You can, it's, yeah.
Okay. Thank you.
I don't think so. But just in case, if you want to review the beginning of the recording, then feel free to do so. I don't think I said anything other than just what I do.
Okay.
Okay. Yeah, I didn't ask you guys to introduce yourselves. I don't know if the other instructors did that because the last time I taught, I took roll and everybody said nobody takes roll. So I just started teaching today.
Oh, wow.
So, but I am seeing who is online. And the only people I'm missing are Veronica and Ladara, or Ladaria. I think that's the I, Ladaria. Those are only two people I don't see online. Okay. Any more questions about the discussion board?
No.
Now we'll move on. Okay. So we're still talking about an offer. So how can you terminate an offer? Okay. You terminate an offer by rejecting it. You say no. Or it might revoke. So the offer, before you accept, the offeror can revoke that offer. So if I say, I want you to wash my car, I'm offering you to wash my car for $10. And then before you answer, I say, no, that's okay. That's okay, I'll get it washed at the car wash. Okay, I've revoked that offer before you've accepted it.
Oh, okay.
That's the way to terminate an offer. So that the offeree can reject it, or I can revoke it as the offeror, or I can lapse if I say, I need to hear from you by 5 today, and it's 5:30 and I haven't heard from you, then that offer has lapsed. And then if the offeror, if I die or I'm incapacitated in some type of way, that offer, it terminates. Okay, so that's how you would terminate an offer. Yes.
Professor, I'm just thinking from an HR perspective. Sometimes we may make contingency offers contingent upon completing the drug test or passing the drug test or confirmation of educational or some type of credential. Now, now in the event that we've made that offer and now, we have viable reason, we call it rescind. We can rescind the offer if the said individual doesn't meet the terms or qualifications. Is that the same thing?
Yeah, you're rescinding, you're taking it back. I mean, that offer, it's a condition basically. Yes. And if that condition doesn't happen, then there's no contract.
Okay, perfect.
You're not bound to hire that person.
Right.
We can't force you to hire them.
I just wanted to make sure.
More like an express condition. It's condition.
I just wanted to make sure that I was thinking of that in the right way.
Yes, absolutely.
Revoking.
Yes. Okay. So offers are revocable even if identified as irrevocable. The exception is the promise not to revoke is supported by some type of consideration. Consideration means you add something to it. The promise is enforceable by statute or you induce some type of reliance. That's what we talked about before. You can't revoke something if somebody's relied on it. For example, go back to our Black Friday deal, right? You can't revoke that offer now because I've camped out for 3 days, okay? And so that's an irrevocable offer. They have to give you that TV if you do that. Okay, so what is acceptance? Remember, mutual assent or an agreement requires offer and acceptance. Acceptance is basically you accept the terms, and when is it effective? Basically, it's effective when you communicate it. So silence is not an acceptance of an offer unless that's expressly stated. There are 3 requirements for acceptance. Basically, the offeree must have knowledge of the offer. You can't accept, cannot. You can't accept something you don't know about. Like my son, with me thinking I'm going to ask him to wash my car, if he doesn't know that, if I never communicate it, right, he can't accept it. And then only the offeree can accept the offer. Okay, my daughter can't accept the offer for my son. And then the acceptance must be in the form authorized by the offer. So if I say, email me your response, then you need to email me your response in order for there to be an effective acceptance. And in some cases, you know, the court will look at it justly. So if I say email me and then I happen to see you at the grocery store and I say, oh, I got your offer. Yes, I'm going to wash your car. I've accepted because it's reasonable, right? Even though I said email me, I saw you and I accepted. So if you say, oh, you didn't email me, so I'm not doing it, you know, the court's not going to look on that fairly. So, you know, you got a verbal, in your face acceptance. So you can't rely on, well, I told you to email me and you didn't email me. You know, and the court will look at it equitably, so that you know, justice is found. Let's see. So acceptance of an offer must be communicated to the offeror. Typically, acceptance is contemporaneous to the offer. I make you an offer and you accept at the same time, or at that time. So how effective is it, an acceptance? Acceptance was either unilateral or bilateral. Unilateral acceptance, performance of an act evidencing acceptance of the offer, right? I'll give you $10 to wash my car. If you wash the car, you have unilaterally accepted the offer. You washed my car. Okay. Bilateral acceptance is a return promise or agreement to the offer. So basically, you say, if you wash my car, I'll give you $10 and then I accept it. There's a bilateral acceptance. A unilateral, if I don't say anything and I just go wash your car, there's an acceptance also. But that's traditional. Typically, the court will look at it now just what is a reasonable manner of acceptance, right? An offer may be accepted by any reasonable manner of assent. Back to the case of when I say email me and then I see you in the grocery store, I run into you in the grocery store and I say, oh, I accept. Well, you know, the court or the contemporary view is that you've accepted the offer.
Or conduct?
Yes.
Or by conduct?
Right, or by conduct. And so where the offeree, there is an exception where the offerer stipulates that acceptance must be done in a specific manner. For example, even if I see you in the store and I say, well, you still got to email me so I know exactly what you want, okay? Then you really need to email that person, right? Because they've stipulated, even though you ran into them, they stipulated, they said it before, and then when they saw you again, they unequivocally said, email me so I know. Right? So that's what you need to do.
Okay, so basically it's not binding until the email is complete.
Right, exactly. If that was firmly stated. If an offer is accepted, why is it important for the contracting parties to have the same understanding of the contract terms? We went over that earlier, right?
Right.
Yeah, so about the Ferrari. Rather.
Right. The Honda versus the Ferrari.
Yeah.
So what happens when the acceptance includes additional or different terms?
It'll be conditional.
That becomes a counteroffer.
Yes. Sometimes it's a counter offer. Sometimes it might be an acceptance of what you agreed on, and then you have to agree on those new terms or additional terms. So under the Uniform Commercial Code, remember we're dealing with the sale of goods whenever you talk about the Uniform Commercial Code. Acceptance will occur even if it contains additional or different terms, so long as it contains all of the negotiated terms of the transaction, price, the quantity, delivery terms. The exception would be if the offeree states that the offeror must agree to the additional or different terms. If the contract is between merchants and the parties show an agreement to the terms. So that's under the UCC. But typically, if it's not under the UCC, it's a counteroffer. Looked at as a counteroffer. Let's see, additional terms are proposals that only become part of the contract upon the sent of the offeree under the Uniform Commercial Code. And then there are 3 different approaches. You treat the different terms like a different additional terms. For example, if you have additional terms, if there are different terms, not additional. You treat the different terms like additional terms. That's one approach. The other approach is they fall out. If the different terms, they drop off or fall out of the contract because they're different. But the contract is for everything else that is the same between the offer and the acceptance. The other terms that are different fall out. And then the majority approach is if the different terms are conflicting terms, they knock each other out and neither become part of the contract, okay? And this is dealing with the UCC. Okay. So if there's imperfect acceptance, additional and or different terms expressed in an acceptance become part of the contract if they do not diverge in any significant way from the terms of the offer, and the offeree does not condition acceptance on the express assent of the offeree to the additional and or different terms. For example, if I say, will you wash my car and I'll pay you $10, right? You accept, but you say, oh, but you have to bring it to me on Saturday. You know, that's something different. My offer didn't say anything about when you were going to do it or if I had to bring my car to you, right? So the agreement is to wash the car, but does me saying or the offeree saying you have to bring it to me on Saturday, that's different or additional from what the offer was. So they may or may not become part of the contract unless I say, you know, you got to agree to that. And if you agree to it, then, you know, there's a contract that includes those different terms. Otherwise, I'm only obligated to pay you $10 if you wash my car, whether or not I bring it to you or not.
Well, that is in a verbal content though, right?
Yeah, that's verbal. It could be verbal or written.
Okay, because I'm just thinking about something.
Okay.
No, because I was thinking like, you know, I mean, if that was a printed offer or something like that, and we read it, but usually you would say like bring it on only on Saturdays or something like that between whatever hours in small print.
Right. Then that's an issue of, did you have notice of that, of those terms? If it's in small print and it's you're required to have that notice, and it, you know.
Yeah, I understand.
That may or may not be.
Yeah, because I have actually done something like that before, and then like you didn't read the small print, you know.
Right. Well, yeah, I mean.
They were like, oh, yeah, okay.
Yeah.
Okay. You just brought back some memories on that one.
Okay. So what about indefinite and deferred agreement, indefinite and missing terms? No contract if the terms are so indefinite that it would be difficult or impossible for the court to detect a breach of the contract, or it would be difficult or impossible for the parties or for the court to provide a remedy to the parties. You know, if there's so much, if you're talking and you don't really know what the terms are, then there really isn't a contract. If the court can't look at it and say, well, there's a contract for this. If there isn't enough to go on, it's not enough information, or it's not specific enough, then there's no contract. There's no agreement. So summary, contracts require both an offer and acceptance, which is mutual assent. The parties must intend to be bound. And the parties must have the same understanding of the terms of the deal. You have to agree. You have to know what you're agreeing to, right? And if you don't, then there's an issue of whether or not there was that mutual assent. Sometimes they call it a meeting of the minds. You have to have a meeting of the minds. Go back to the red Ferrari. It's pretty ridiculous, but it's to, you know, make a point. You know, if you're thinking Ferrari and the other person's thinking a Honda Civic, you know, there is no mutual assent. There is no agreement. And so that's why it's very important to have that for there a deal to be made. Remember, we're answering the question, has a deal been made? And that would require both the offer and the acceptance on the same terms and the understanding of the same terms. You have to have that same understanding. And then if there are any additional or different terms, then they may or may not become a part of the contract, depending on if you're a merchant. And if you're a merchant, then more likely than not, they will. And then if you're not, then it just depends on if you say you have to agree to these additional terms. So are there any questions about the course, about offer, acceptance?
I have a question really quick.
Yes.
In the first chapter, it talks about like missing terms, and it talks about having some vagueness. And I was really confused about how much vagueness, because it says enough is okay, or a little bit is okay, but not too much.
As to the terms?
Yes.
Right. If you go back to my car washing, you know, you have an agreement for my car to be washed, right? And so whether or not, you know, I bring it to you or you bring it to me, you know, is that vague? You know, maybe you didn't discuss that, you never thought about it. But what happens if, you know, you've watched this person's car before and they've always come to you, right? It wouldn't really affect the terms of the deal if you say, oh, well, I meant for you to bring the car to me this time.
Oh, okay.
Okay, think about it in terms of that. You know, is it something that is curable, or is it so vague that it affects the whole purpose of the contract?
Okay.
Right? If it's something that it affects the whole purpose of the contract, whereas you don't know what you're contracting for, or you can't identify the terms of the contract, then that's what they mean by a little vague.
Okay.
Versus, you know, if it's something that will affect the whole deal.
Thank you.
Let's see, I think I had some more. Let's see, definite terms.
Professor, I have a question concerning, well, I don't know if you're familiar with the OfferUp app.
I can barely hear you, and somebody is sewing or doing something that I hear.
That might be my ceiling fan.
Can you hear me?
Yes. Who's talking? Oh, Margarita?
Margarita.
Okay.
Can you hear me?
Yes.
Yeah, I don't know if you're familiar with the Offer Up app. There's an application on the phone that's Offer Up, and people just put things there, advertise things to sell. And like for instance, in this case, my husband's we've been trying to sell this van, and he has gotten several. He has offered it, and he has gotten several people who said, "Well, yes, I would like to," but they don't show up. They would like to purchase a van. There's a time set up. There's the money's arranged, and they don't show up.
The money's arranged in the sense that you've told them how much and they've accepted.
Exactly.
And then they don't show up to get it, or they don't show up to pay for it.
They don't show up to get it. They don't show up to close the deal. So how binding is that? Because it's just an offer. It's an app, and it's an offer up a app, and is it like a binding contract or no?
Well, that would depend on what communications you had with that party post offer, because you're offering this van for you're negotiating best price, right? Or you have a specific price. And so if they are accepting it, then more likely than not, it's something you probably could. But then that would also depend on the terms of the app you are using, and then how specific the communications were to you that they wanted. The fact that maybe you've arranged a time and date for them to pick up the vehicle, that makes it more specific.
Okay.
And so, but I don't know with that app how far the courts would go to enforce it, like to make the person take.
Exactly, I was wondering. Okay.
Unless you, the only thing I would say is, base it on them providing the money, right? If you're interested, I'll send you a link and you pay this money or however, and then they're serious. But if you look at it in terms of, if you go back to our example as far as an advertisement, it may be more of you're inviting them to offer.
Okay.
An invitation to offer as opposed to, it's just an advertisement.
Okay, so I need to be a little more specific in my offer.
Right. And if they're interested, then they need to pay you. So if you send them a link like your PayPal or something, you say, pay this money, and they pay it, then you've got a deal.
Okay. I'll try something like that.
Yeah. And so I have a few more slides. That was a death or incapacity, lapse of an offer. The mailbox rule. Basically, that's saying that an offer, when an offer is made by mail, acceptance occurs when acceptance is dispatched in the mail, not when the offerer receives it. So if I mail you an offer and then I mail back the acceptance, when I put that letter in the mail accepting, that is a contract has been created because I sent it in the mail. You don't have to wait till the person receives it for there to be an acceptance. That's the mailbox rule, basically.
Does the mailbox rule?
Is it in it? That's like being blindsided.
Does the postmark date, is that a variable or no?
I mean, it could be because it's evidence that you mailed it. Basically, the postmark. It's evidence that you mailed it. The question would be, is it in your inter-office mail and that they're not going to pick it up until next week? Right. Like it's Friday, and you put that offer in your inter-office mailbox, but that the mail won't be picked up until Monday at 10 a.m. because you got it in too late, right?
Gotcha.
So then you probably haven't really dispatched it.
Right.
I mean, technically you have, but that's inner office, and you know that the mail won't be picked up.
Right.
Someone
Right.
raised their hand. Is that you, Latina?
Mutual assent or mutual understanding. If you have a legal representation for your contract, but the understanding of your counsel did not reflect what your understanding would be for a contract, is that still considered mutual assent? I mean, mutual consent or mutual understanding? Maybe that's the terminology I should be using.
Mutual assent. If what, I didn't understand what you said about counsel. What's the difference? Is there a difference in understanding about the representation? Is that what you're saying?
No, ma'am. It's the possible terms. So the meeting of the minds is referred to, where we have an understanding of what an offer is, but the other person has a different understanding of what the offer is. But the understanding that the second party received came from their attorney, and the understanding that they received from their attorney was not the understanding that they believed was protecting their interests. That's still a situation where, as the other party is concerned, because they say, well, you had an attorney, and that's a professional representation, there's a meeting of the minds there, because despite if the attorney is representing your actual intent or not, your issue now is with your attorney, not with us. Is that still considered?
Understanding you correctly, you have an agreement with a party, but that party has an attorney. And what the attorney told the party is different than what you've discussed with the party. Is that what you're saying? And so now, because the attorney's involved, there's a whole different meaning that you didn't agree to. Is that correct?
So I will be the one to have the attorney in the scenario. And the agreement that represented was not my understanding. But the other party is saying, because the attorney was speaking on your behalf, whether it was an adequate representation of your intent or not, whatever the attorney represented at that time is what was the same thing that we agreed to. So now there's a binding contract.
Right. Exactly.
The issue now is with the attorney, not with us.
Right. Exactly. That's true. Because if you are represented by an attorney, and the attorney is speaking on your behalf, and so that's why, as an attorney, they should communicate with their client exactly what the understanding is of the agreement that they are going to make on your behalf, because you're the client. You are the one that has to agree or not agree. And if they represent that they're speaking on your behalf, an agreement is made that you didn't agree with, then yes, your issue is with your attorney who represented you, not with the other parties. Because they didn't do what they were supposed to do by making sure you understood and that you agreed to, or you had the same understanding that the other side had when they entered into an agreement on your behalf.
And that's the agreement is binding.
The agreement is binding. So your issue would be with your attorney representing or not. That's a misrepresentation of you and your interests. Does that make sense?
Yes, ma'am.
Yeah, okay. All right, and so let's see, acceptance under the restatement, that's the mailbox rule. That's the book, we won't go over there. So what happens when the offeree accepts conditioned upon additional or different terms from the offer? We went over that. Is the acceptance effective? Maybe it is. And then the mirror image rule. So basically, the older view or traditional view is that the acceptance had to mirror the offer. It had to be exactly what the offer was. I accept everything in the offer. And then those additional or different terms would then become a counter offer. The offeror, the offeree becomes the offerer. Okay, they counter offer. Then the original offeror will have the power of acceptance to accept those additional or those different terms. And I think we went over that. The traditional view, if there's indefinite or missing terms, the contract or purported contract is so vague that it cannot be enforced. We went over that. The modern view is that courts are more willing to imply missing or unclear terms. So the court is always trying to look for an equitable way to fashion a remedy and to try to find a contract if there is one, to look at the intention of the parties. What did they intend? So pre-contractual liability. Basically, you might have some negotiations, but until there's an actual agreement, then you don't have any obligation to one another. The exception would be letters of intent, where you say in business that you will negotiate to complete an agreement. You intend. It's like, I will enter in good faith into negotiations with you to come up with an agreement. And that's a letter of intent. And so typically the courts will enforce those letters of intent. If you say, I will negotiate with you, and then you don't, then you have to at least give that party, an option to, or at least good faith, enter into good faith negotiations with them. And you can't walk away without making a serious effort to come to an agreement. And then I think that was the last slide. Question?
Yeah, I have one. Was this an updated PowerPoint? Because I printed it out and several of the latter slides weren't in there that I found very interesting, like the mailbox.
That was an updated slide. I will put that one in.
Yeah, okay. And did you?
It's an updated slide.
Okay. Yeah, because I'm like, wait, I don't have that. And then what about chapter 2? Are you going to post those? I love PowerPoints. Are you going to post those as well?
Yes, I try to. Well, PowerPoints for chapter 2.
Yeah. For you to do.
So. I don't think so.
Okay, because I noticed some of them it had PowerPoint, but there wasn't anything there. So I just was checking.
Oh, the PowerPoint, they put that
all the help I can get.
There won't be PowerPoints for every.
Okay. I can respect that.
Okay, any final questions before we go?
No. I have one other question.
Okay.
It's germane to Johnny's post, actually, about the auction. Johnny had a
post about the auction.
You didn't see it? Well, Johnny, do you want to describe your post? Anyway, he had a very...
He's not with us. No.
Oh, he's gone? Oh, okay. Well,
he's muted.
Oh, okay. He had a very interesting...
I'm back. I had to find my place.
Okay.
Okay. What I did, because like I said earlier, I said I wasn't quite sure if I did it right and stuff, but I had recently bought a car at an auction.
Okay.
And I don't have what, but anyway, I kind of like ad-lib it here. But and I had, let's see, and I kind of like explain how the auction process goes, and myself as the participant, I guess.
Okay.
And I think I entered myself on there as the offeree.
Mm-hmm.
The offeree and the acceptor, because I believe those could kind of like interchange, because I think once certain things has taken place, from the point of where I bidded on the car and won the bid, but
Yeah.
I still didn't have right to the car until I actually put some skin in the game. What I call it, when I put my money down as a deposit,
Right,
on that, and then that's when we actually started writing and stuff with my name on it and stuff. And then when I came back the following day, that is when I solidified it. When I gave them all the cash and they gave me a clear title and a bill of sale, and that was my recent contracting experience.
So the question that I had with that is, as he was identifying the terms of agreement, and I've never been to an auction, so I'll put ignorance on that part. But my concern was, as they don't have a contract where, for example, they're disclosing anything wrong with property, because he's saying, I take all responsibility. So
in a car situation with an auction, you are taking it as is.
Okay, that was
when you're auctioning property, the same thing. We do that now. We have investors on some of the properties that we have cited, and they might purchase those properties and not do their due diligence and not realize that they owe the city $20,000, but they bought that property in auction. And they don't know that if they have that $20, they see that lien from our city, and they don't do their due diligence. They buy that property and they don't realize, oh, you got to pay the city $20,000 before you can take.
Yes, because
any liability that would be associated with that, or any malfunction with the car. When he said, I take full responsibility, he was also saying, I'm taking that liability as well. So, okay. I just wanted
the contract was probably made prior to them exchanging the title and the money. The contract was made at the auction. I'm auctioning off this car for this amount of money. You win the auction. There's a contract.
And there's no
at that point, it's a verbal contract. Considered a verbal contract.
There was a contract. What did you say?
That's what I was saying. At that point, it's considered a verbal contract, right?
It's a contract. Verbal is a verbal contract.
Yeah,
it's a contract.
Yeah, okay. Contract.
Jacqueline, what did you say?
I was just saying that, when we think in terms of reasonable person, reasonable standards, etc., would there be an obligation by that auctioneer, or even in the case of property, the offerer, to disclose that kind of information? But I think you answered it, because you said, no, it's up to you to do due diligence to make sure that.
Yeah, especially in an auction situation. Because typically in an auction, unless you're doing like, rare goods and things like that, higher end things.
Right. Because then you get.
You know what you're getting. You might get,
Okay.
Not the
might get a good one
in your bargain.
Get a lemon.
Okay.
Right. And it's typically auctioned off at a reduced rate than what the normal market price would be. That's why people go buy cars at auction, because you're getting it for probably under market.
Okay.
Yeah.
All right.
Around this time of the year.
Okay. So it is 7:08. Our class is over. If you have further questions, feel free to email me. And I will try my best to answer them, especially probably by Monday, because I teach on Saturdays also. So Fridays, I'm typically preparing for class. So just, I might not get to you right away.
Okay.
That's all I want to say, but I will. Okay, and I look forward to your participation this session. And also, on the final, I will write the final. I'm working on the final because I'm switching it up from the last session. It will still be biblically based, but I'm going to make it more of a fact pattern with the contract. And so I'm working on the final. but that's in week 7, so don't worry about it.
Okay. Okay.
All righty.
No.
All
God
right,
bless.
everybody take care. Be safe
Everybody
tonight, all right?
Thank you.
Bye.
Yes, sir.
Okay.